Welcome to Rise from the Ashes. Our podcast looks at various issues for families. We'll be talking with attorneys about personal and legal concerns having to do with divorce, custody, and parenting time. There are also a few topics about letting go, moving on, and new beginnings. Please keep in mind this podcast is only to inform and help to understand legal and personal issues as it relate to family law. It should not be considered as a replacement for a qualified family law attorney. When in doubt, please contact a professional. Rise from the Ashes, focusing on matters of the family because family matters. Hi, and welcome to our podcast, Rise from the Ashes. I'm David Braddock. I'll be your host for the podcast, and we're talking today with Susan Mundahl of Mundahl Law. How are you today, Susan?
I'm great, David.
Now, today's topic, why are we talking about pretrial?
That's a really good question. The reason is that I get most of my cases settled at mediation. But recently, I had a client. We were unable to reach an agreement at mediation. The pretrial was coming up, and she said, Susan, what's a pretrial? And I thought, oh, okay. I think this is a great topic to talk about in a podcast.
All right. What exactly is a pretrial?
What a pretrial actually is a pre-hearing conference. And the purpose of it is a last-ditch effort required by the courts for you to stand outside a courtroom or in a conference room near the courtroom to try and settle your case, because the court does not want to go to trial. They want you to do everything you can to try and settle it.
They actually provide a space for you in a conference room. Depending on what happens, you may be going into that courtroom or you may not. Is that correct?
That's correct. What happens is that generally they'll come out and they'll say, all right, you've got 3 hours. We expect you to try and get this settled. The advantage of being at the courthouse is twofold. One, it gives the attorneys an opportunity to talk to the court in chambers, which means in the judge's chambers, without clients being present, to ask what the sticking points are.
What kind of sticking points might we be talking about?
Sometimes they're fairly simple, but they just can't reach an agreement. Like, is the court going to require them to divide the tax refund? And it seems fairly simple. Or what is the value of the home?
It seems like retirement accounts could get into that type of discussion. Insurance.
Yes, so there's money questions. And to try and decide which way the court's going to go, usually if it's a non-marital versus marital question, what the court's going to look at in doing that. And what we're looking for is a hypothetical from the judge.
Hypothetical in what way?
Meaning, what would be the legal standard that a judge would use in making that decision? Let me give you a concrete example of that from custody and parenting time.
Okay.
I had a case a few years back where the husband wanted every weekend parenting time with the children, citing that the wife was able to have the children during the week. And my position to the court is, no, weekend parenting time is different from weekday parenting time. And they were adamant that he insisted on this 4 weeks. So we needed a judge's opinion. Well, we went into chambers and the judge said, actually, weekend parenting time is different. And if this case were to come to me, I would say that husband only gets every other weekend. And so we were able to go out and actually negotiate a settlement. So he had 3 weekends a month, which was reasonable in that particular case.
You were able to go out to this conference room situation during that same session or that same day?
Yes, and we were able to go back to the clients and say, look, the judge said this on how he's likely to rule in this particular matter, so that then we could get the clients to take a more reasonable position so that we could reach a settlement.
When you say that you're going into chambers with the judge during this pretrial process, we understand that there's a conference room and you're probably meeting with attorneys and clients in there. It sounds like you might be saying that it's just attorneys who are going into chambers with the judge to try to sort out what these sticking points might be. Is that correct?
Yeah, that's right. What we do is we just call the judge's clerk and say, we need to talk to the judge a minute. We have a few issues we want to discuss. And then we have access to the judge to be able to do that, with the goal being that if we reach a final agreement, we are then taken into the courtroom. The clients are sworn under oath And then we put the agreement on the record. And then one attorney is assigned to draft the stipulated judgment and decree. Or if the parties are prepared, maybe we have a draft of a judgment and decree and we just put a few handwritten remarks on it, in which case that then is submitted to the court at that time. And then they can still get their divorce that day.
It sounds like in that circumstance where you're going in to sort things out with the judge's assistance, that the judge is actually helping in this settlement process.
That's right, David. And that's exactly why they have these pre-hearing conferences, is to try and get the parties to come to a final agreement with the judge's assistance.
That is really interesting. It's like it's totally proactive interaction with the court as well as the attorneys and the clients to really try to get a package that works for everyone.
You've got it. It's as simple as that and as complex as that. But it is a really important step. Then there is a final piece to it, is if the parties cannot reach any agreement, then it is to go on the record with the court to set the matter on for trial. And at that point, the court will then issue a pretrial order and order the parties to do witness lists and exhibit lists and all of those things to prepare for a very expensive trial.
And that sounds like what everyone is trying to avoid because of the costs and the time and everything involved.
You're absolutely right, David.
But is there anything else that can be done to get a case settled short of going to a trial?
There actually is a process. It's called the Moderated Settlement Conference. It's not available in every county, but it certainly is in Hennepin County. It's a hybrid of arbitration mediation. The Moderated Settlement Conference, it is meeting with a mediator, but it's a mediator who is on the court's list of moderated settlement conference providers. So it's experienced attorneys generally. Their goal is really to try and strong arm, so to speak, to really put pressure on the parties to try and reach a settlement. Because of their experience, they can provide evaluation, and sometimes they can get the parties to reconsider their positions enough to reach a settlement without going to trial.
So their goal is to try to find the kind of appropriate compromises that will actually work for both sides.
That's right. You know, I have one thing to say about that. If you have used a particular mediator prior to pretrial to settle the case and that mediator wasn't able to settle it, don't use that mediator as your moderated settlement conference person. I saw that happen in a case. Of course, they were unable to get them to change their minds. They'd already had 2 bites of the apple in that particular case. There had been 2 mediations. They hadn't gotten them to reach an agreement. So why would someone go to them a third time?
It almost sounds like going to the doctor. Sometimes it's good to get a second opinion.
I think that's a really excellent analogy, David. I think you need someone fresh that can look at the situation in a fresh way and maybe provide a different perspective to the parties.
And hopefully everything will go much, much better.
Certainly that's the hope, and I've seen it happen a lot of times. That's why the courts use it.
Any parting thoughts or advice on this topic?
I think the parting advice is do everything you can to get your case settled. And the earlier you settle it, the less entrenched you are in your position, and the more willing you are to negotiate a settlement will cost you far less money in terms of money and also in terms of time and also your emotional investment.
Well, thank you so much, Susan.
You have a great day, David.
You are listening to Rise from the Ashes, the podcast channel that takes a careful look at all things having to do with legal procedure within the family law process. Rise from the Ashes is sponsored by Mundall Law, who specializes in assisting families and individuals through the legal process with respect, dignity, and caring. Mundall Law is dedicated to helping people to solve their legal problems. You can visit the Mundall Law website at mundalllaw.com or call to schedule a consultation with one of their qualified family law attorneys. Rise from the Ashes, focusing on matters of the family, because family matters.